And when asked about President Obama's stated belief that what's in a person's heart should influence the outcome in a case, she said, "I wouldn't approach the issue of judging the way the president does. Judges can't rely on what's in their heart. The job of a judge is to apply the law." Good for her. But think about what that quote actually did. Here, a judicial nominee, now a current justice on the United States Supreme Court, has publicly repudiated the standard expressed by the president who nominated her. And no one on the president's side of the aisle stood up to defend his position, and few people outside the committee room even noticed. So, what are some conclusions we could draw? I would say the first conclusion is that judicial activists are scared to defend their philosophy in public and have embraced the rhetoric of judicial restraint. And secondly, we have seen, and this is another, I think, very important development, is that the left has tried to attack advocates of judicial restraint, most notably Justice Alito and Chief Justice Roberts, as judicial activists. For example, Al Franken has said the Roberts Court, specifically and most egregiously Clarence Thomas, has been very activist. Thus spoke Al Franken. I'm not sure what qualifies him to make that judgment, but he's a United States Senator, and he's certainly entitled to express his opinion. Senator Feinstein from California defined judicial activism to mean that any time a court overrules an earlier precedent, she basically said that's judicial activism. And Senator Chuck Schumer said this 2 years ago. He said, "In case after case, our most recently confirmed justices has appeared to jettison decisions recently authored by their immediate predecessors. The decisions this term were especially cruel," he said, "advancing the traditional conservative preference for the government over criminal defendants and the interests of business over consumers and employees." I believe these allegations are demonstrably false. We all understand what judicial activism really is. Judicial activism is the substitution of a judge's policy preferences for those of the elected representatives of the people, or the document that we have ratified as states when we joined the Union, the U.S. Constitution. Judicial activism emphatically does not mean reversing previous decisions which were themselves a product of judicial activism, or striking down laws that limit the fundamental liberties enshrined in our Constitution. Judicial activism, at its core, represents a repudiation of the separation of powers doctrine embodied in our Constitution. John Adams wrote it as fundamental that judges shall never exercise the legislative or executive power, or either one of them, so that our laws can be a government of laws and not of men. Judicial activists reject the view expressed by Chief Justice Roberts at his confirmation hearing, when he memorably used the analogy, which seems to drive the left absolutely batty, of a baseball umpire calling balls and strikes. Instead, they would say that a baseball umpire's personal sympathies or wishes for an outcome in a contest would be decided by just that, and not by the rules of the game. So judicial activism is not a difficult concept to understand. We've seen many examples of it over time. For example, we've seen judicial activism in cases involving the war on terror, in which judges have invented rights for enemy combatants never before recognized by any court in this country, and in fact overruling earlier decisions dating back to World War II. We've seen judicial activism in cases relating to the death penalty, where the Supreme Court struck down laws enacted by many states for crimes, heinous crimes committed by those under the age of 18, invoking foreign law in the process. And we've seen judicial activism in places like California, and indeed right here in Dallas, Texas, where judges have imposed their own views with regard to same-sex marriage and who can legally be married, or I guess in this case, who needs to be divorced in a court of law, I think is another example of making it up as you go along. The American people understand what judicial activism means, and they don't like it very much at all. 63% of American people have said, I wish it were 100%, but 63% said in a recent poll that judges should make their rulings based on in the law, and including the Constitution. Well, so many Americans disapprove of judicial activism, yet the left continues to try to advance false charges of judicial activism among those who are doing their best, I believe, to exercise the role of the judge modestly and with the kind of self-restraint that respects the separation of powers and the right of the American people to determine their destiny, not the right of unelected, lifetime tenured judges to tell us what's good for us. Well, I want to just close by just saying a couple words about the great judges and prosecutors we have who are part of our federal judiciary and our legal system. And close on this, on a very important issue, at least to me, about what kind of people should be confirmed, not only as district judges, circuit court judges, Supreme Court judges, but also as United States attorneys. Now, some of you may have seen that Senator Hutchison and I have a bipartisan group of lawyers, some of the most outstanding legal professionals in the state, to screen our judicial nominees, or U.S. Marshal nominees, or I should say the President's nominees, as well as the U.S. attorneys. And many of you know that Senator Hutchison and I have worked very closely with the White House to try to make sure that this process is fair, that it's inclusive, that anyone and everyone who wants to apply can find a pipeline into making sure that their credentials are reviewed, and that anyone who is selected be selected because they indeed are among the best and brightest, not because of politics. Well, in the case of the U.S. Attorney here in Dallas County, you may have seen that Senator Hutchison and I have sent the name of Sarah Saldana to the President and said that if he saw fit to nominate her, then we would certainly work to see that she would be confirmed. It's, as you know, Ms. Saldana is chief of the Northern District's Fraud and Public Corruption Division. She's received overwhelming support from the legal community, and she very much impressed Senator Hutchison and myself in our face-to-face interviews. We know that the White House is also a fan of hers, because originally they sent her name over to us as a potential nominee for pre-screening. But apparently her nomination is opposed by one or more members of the Texas House delegation. But I have yet to hear a single legitimate reason offered why Ms. Saldana would not be a good nominee and serve with honor and dignity as United States Attorney in Dallas in the Northern District of Texas. I'm concerned that the real reasons for this opposition are rooted more in politics than the merits. But for those, including some of our friends in the Texas congressional delegation, who believe that somehow the Senate should not be involved in the confirmation process, I would urge them to reread Article 2 of the Constitution and maybe acquaint themselves with the practices and procedures and precedent of the U.S. Senate when it comes to something called the blue slip. It's very important that only the best and the brightest get confirmed to serve in these very important positions. And I believe that Ms. Saldana is the best qualified lawyer of the people that were reviewed by the evaluation committee and the people who I have personally interviewed to serve as a United States Attorney in the Northern District of Texas. It's ironic that she's not exactly a rock-ribbed Republican. She's a proud Democrat. She's a career prosecutor, as you know, who has not shied away from controversial or tough cases, and who clearly understands that no one is above the law.